Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's recap the important Supreme Court judgments from the summer break. The Supreme Court has recognized the authority of the Bar Council of India to make rules for the enrollment of advocates in addition to the condition provided under Section 24 of the Advocates Act 1961. The vacation bench of Justice Sanjay Kumar and Justice Vikram Nath upheld the validity of the rule mandating that for enrollment, candidates must have completed their law courses from a college or university recognized by the BCI. The court referred to the recent decision of the Constitution Bench of the Supreme Court in Bar Council of India versus Bonifoy Law College and others. The Constitution Bench took up for consideration the decision in B. Sudhir and held that it to be not good in law. The bench held that BCI's role before the enrollment of a candidate cannot be ousted, and the ratio decidendi in V. Sudhir was erroneous in holding that it was not one of the statutory functions of the BCI to frame rules imposing pre-enrollment conditions. It was categorically held that Section 49 dealt with Section 24(3)(d) of the Act of 1961 vested BCI with the power to prescribe the norms for entitlement to be enrolled as an advocate. As a consequence, the indirect placed by on the decision in B. Sudhir on the power of the BCI was unsustainable. The Constitution Bench accordingly held that V. Sudhir did not lay down the correct position of law. Relying on the ratio in BCI versus Bonifoy Law College, the Supreme Court set aside the impugned order of the Orissa High Court and observed the rule framed by BCI requiring a candidate for enrollment as an advocate to have completed his law course from a college or recognized university by the BCI cannot be said to be invalid. The Supreme Court has observed that the involvement of a person who is not mentioned in the FIR as an accused should be in the commission of a crime must be proved beyond a reasonable doubt at the stage of a charge being framed to be tried, along with the person mentioned as an accused in the FIR. The vacation bench of Justice Jitendra Nath Mishra and Justice Dipankar Dutta observed that for exercising powers under Section 319 of the CrPC, it is essential for the evidence on record to show the involvement of a person who is not mentioned as an accused in the FIR in the commission of crime, and the said person should then face trial together with the person accused in the FIR. The Supreme Court has held that once the NCLT is convinced that a default has occurred, it is obligated to admit an application under Section 7 of the Insolvency and Bankruptcy Code, regardless of any dispute or the state status of the debt being due or not. The vacation bench of Justice Abhay S. Oka and Justice Rajesh Bindal, referring to prior apex court rulings, explained the scope of Section 7 of the Insolvency and Bankruptcy Code. It emphasized that the NCLT, as an adjudicating authority, must determine the occurrence of a default based on evidence provided by the financial creditor. Once satisfied with the existence of a default, the adjudicating authority must admit the application unless incomplete. It was further emphasized that the dispute nature of the debt is irrelevant as long as it is due and payable. The Supreme Court has issued a partial stay on an Orissa High Court order that invoked parents' patrie jurisdiction to restore the custody of a minor Muslim girl to her father in a habeas corpus case. The parents' patrie jurisdiction grants courts the authority to act as a parent of a child or individual in need of protection. The vacation bench of Justice B.V. Nagaratna and Justice Manoj Mishra also sought a response from the Orissa government regarding the matter. The case, which raises important questions regarding the territorial jurisdiction of high courts in habeas corpus cases, pertains to a father who had approached the Orissa High Court alleging the illegal detainment of the child by his niece and elder sister. The High Court had ruled that the technical objections regarding territorial jurisdiction should not hold significant weight in such cases. It cited Article 226(2) of the Constitution, which empowers High Courts to issue writ to individuals, authorities or governments beyond their territorial limits in a partial cause of action arises within their jurisdiction. The court had also noted that proceedings under the Guardians and Wards Act initiated by the father's niece and sister for the custody of the child were still pending. Accordingly, it was directed that the authorities to ensure that the child is returned to the father by the end of June. Next, we have Delhi High Court. The Delhi High Court has held that advocates running offices from residential buildings will not be charged property tax by the Delhi Municipal Corporation as a business building, while holding that the professional activity of lawyers cannot be seen as commercial activity. A bench of Justice Nazmi Waziri and Justice Sudhir Jain said that the Master Plan for Delhi MPD 2021 permits professional activity in residential buildings subject to certain conditions. It said that the MPD does not allow the corporation to charge tax on the professional activity being carried out from the residential building. The erstwhile South Delhi Municipal Corporation had challenged the judgment of a single judge which held that the services rendered by the advocates are professional activities and hence they cannot be classified, categorized or subjected to tax under the category of business establishment. The case dates back to 2013 when the SDMC issued a notice to a lawyer who was running his office from a portion of his residential premises. The lawyer petitioned the High Court against the corporation assessing property tax on the ground that he was running a commercial activity from the premises. A single judge bench quashed the corporation's order in 2015, leading the corporation to file an appeal. The municipal corporation contended that when a building or a part is used for the transaction of business or for the keeping of books, accounts and records, it shall be considered as a business building and therefore was subject to levy of property tax. The corporation also said that the lawyer's service fell within the sphere of professional activity and that part of a building which is used for professional activity would fall within the definition of a business building under a provision of the 2004 bylaws. It further contended that the provision in the bylaws categorically includes the office buildings premises solely on the principally used as office or for office purposes, that the definition of business building or mercantile building contained in the statutes were extraneous to the determination of the annual value under the unit areas of property tax. The corporation also argued that since the activities being carried out by the advocates and professionals are commercial and non-domestic in nature, therefore they are subject to tax, and simply because such activities carried out from the residential buildings as per permitted under MPD 2021, the activity would not become residential. However, the court rejected the reasoning, underlining that the contention was ex facie untenable because there is no such deeming provision in law for taxation. Citing a Supreme Court verdict of the 2004, where the apex court held that the power to tax must be expressed, else no power to tax, the bench said that the DMC Act, there is no power to tax professional activities carried out from the residential building. Neither the Act nor the bylaws define the professional activity carried out by the advocates, architects and doctors, etc., the court said. Now let's have an overview of other high courts. In a significant ruling, the Madras High Court has set aside an assessment order passed by the Tamil Nadu Goods and Services Tax Act 2017, emphasizing the importance of including the determination of input tax credit in the show cause notice itself. The court granted the company the necessary opportunity to respond and provide supporting details for the claimed ITC. The case revolved around the reversal of ITC claimed by the petitioner, which the assessing officer deemed ineligible and not rightfully claimed. The AO determined the amount to be reversed by comparing the ITC claimed under GSTR 3B and GSTR 2B. Justice Anita Sumant, the single judge hearing the case, found that the determination of the ITC should have been communicated to the petitioner in the show cause notice, allowing them sufficient time to respond and provide necessary documentation to support the claim. The court noted that prior to the assessment order, the assessing authority had issued notices calling for specific particulars, including invoices from the petitioner. However, it remained unclear whether the petitioner had provided the requested information in the prescribed manner and whether all supporting documents were submitted to the AO. The court observed that the impugned order indicated that the AO had based the reversal determination on a comparison of the ITC claimed under the GST 3B and GST 2B. The Bombay High Court has observed that when any woman proves that she suffered domestic violence at the hands of her husband, the degree of the said violence becomes immaterial. The court noted that the object and reason for the said enactment is to provide effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family and for matters incidental and connected thereto. The courts cannot restrict the interpretation of the same by giving a restricted meaning to it. The definition of domestic violence is not restricted to physically or sexual abuse, but also emotional and economic abuse of women amount to domestic violence. The court observed that apart from emotional and physical abuse, petitioner herein has made out a case of economic abuse at the hands of her husband. Thus, there cannot be any reason or justification to deny the relief of maintenance to her. Further, the court said that the Act does not differentiate or determine degrees of domestic violence. Domestic violence does not depend on its severity or proceed under the Act. When any woman proves that she had suffered domestic violence at the hands of the respondent, the degree of the said violence becomes immaterial. The Rajasthan High Court has reiterated the principle that an insurance company cannot be held liable for compensation if the insured fails to fulfill their premium payment obligation or if the issued check for the premium is returned unpaid by the bank. The court's clarification came during the hearing of an appeal against an order issued by the Motor Accident Claims Tribunal, which directed the insurance company to pay Rs 1,88,000 as compensation to the claimants. The court referred to the Section 64 VB of the Insurance Act 1938, which states that an insurance company will not assume or accept risk unless the insurance premium is received in advance or before the date of assumption of risk. To support its stance, the court referenced the observation of the Supreme Court in the case of National Insurance Company Limited versus Seema Malhotra and others, stating that when the insured fails to pay promised premium or when the check issued by them for the premium is returned dishonored by the bank, the insurer is not obliged to fulfill their part of the promise. The insured cannot claim performance from the insurer under such circumstances. The Kerala High Court has ruled that an employer cannot recover an overpayment made to an employee due to negligence or carelessness, especially when the employee was unaware that the amount paid exceeded the authorized sum. A division bench of Justice Alexander Thomas and Justice C. Jayachandran considered the case of a teacher who received an additional increment based on a government order. The court referred to the position laid down in the state of Punjab and others versus Washer case, particularly within the purview of Clause 5th of the situation. According to the section, the recovery of the overpayment by employer is impermissible in law if the recovery from the employee is deemed unjust, harsh, or arbitrary to the extent that it exceeds the rights of the employer to recover. The Calcutta High Court has reiterated the principle that pensionary laws benefiting a homogeneous class of pensioners should be interpreted liberally in their favor. The court held that the government memorandum number 539 SE dated November 1, 2010 still applies to the grant of pensionary benefits to unmarried, widowed, divorced daughters of retired employees or family pensioners in the absence of any provision affecting or restricting the same. A three-judge bench comprising of Justice Harish Tandon, Justice Shampa Sarkar and Justice Rabindra Nath Samanta observed that family pension can be extended to unmarried, widowed daughters of employees who superannuated to or died prior to the implementation of the Death Cum Retirement Benefit Scheme 1981, which came into effect on April 1, 1981. The bench further stated that both teaching and non-teaching staff who retired before or after April 1, 1981 were entitled to pensionary benefits under the DCRB Scheme 1981. In its decision, the High Court referred to the golden principle outlined in the case of D.S. Nakara versus Union of India, emphasizing that the pensioners form a homogeneous class and any classification within that class based on the date of retirement would be arbitrary and a violation of Article 14 of the Constitution. The court highlighted that the legislative intent was to extend the benefits of family pension to unmarried, widowed, divorcee daughters of employees who retired before or after April 1, 1981, or to unmarried, widowed, divorced daughters of family pensioners. The court further noted that the memorandum dated November 1, 2010 should not hinder the extensions of these benefits unless there is an express provision restricting or affecting them. It emphasized the importance of socio-economic justice and the need to interpret memoranda regarding social security and livelihoods to these classes of women liberally. The Allahabad High Court has overturned a murder conviction based on the reasoning that the trial court had relied on the dying declaration of the deceased to convict the accused without presenting it to the accused during his statements recorded under Section 313 of the Code of Criminal Procedure to seek his explanation. A division bench of Justice Siddharth Verma and Justice Manish Kumar Nigam noted that the accused was unable to address a crucial circumstance as he was never confronted with the incrementing details of the dying declaration, which served as the foundation for the conviction. The court noted that it is well established that a dying declaration can serve as a basis for conviction if it is deemed credible. However, it was emphasized that both the facts of making the statement and the truthfulness of the statement need to be established in order to rely on it as evidence. Considering this context, upon scrutinizing the evidence related to the dying declaration, the court raised doubts regarding the timing of its recording. The court also observed that there was no record indicating how the doctor determined that the deceased was mentally capable of giving the dying declaration. Moving on to miscellaneous news. The Aam Aadmi Party government in Delhi has approached Supreme Court regarding centre's ordinance regarding transfer posting of officers. The petition states that the ordinance is unconstitutional as it does not amend Article 239AA of the Constitution and wrests control from an elected government and places it in the hands of an unelected LG. On May 19, the centre had promulgated an ordinance taking the authority of the transfer and postings of IAS and DA NIC's officers of national capital. The Arvind Kejriwal government had called the move a circumventive and apex court of the apex court verdict on the control of services. The ordinance was promulgated a week after the Supreme Court handed over the control of services in the capital except police, public order and land to the elected government. The transfer and postings of all officers of the Delhi government were under the executive control of the Lieutenant Governor before May 11th verdict of the Supreme Court. Delhi Chief Minister Arvind Kejriwal had garnered support from the opposition parties against the centre's ordinance. In fact, he will also burn copies of the ordinance at the party office in central Delhi. The Maharashtra State Human Rights Commission, observing an alarming rise in instances of police apathy and abuse, ordered 4 Nagpur police officers to pay Rs 2.5 lakh as compensation to a lawyer and her husband for the harsh and horrifying ordeal they were made to undergo one night at a police station when they went to complain about a stray being mistreated. The commission wondered that what prevented the police chief from initiating criminal action against the officials and directed the couple was free to initiate criminal proceedings against the errant police official too, said the SHRC order, despite departmental action taken by the city commissioner of the police against the officers. Unless a person is tried for an offence and either convicted or acquitted, the doctrine of double jeopardy, which the officer sought to invoke, does not kick in, and noted that the purpose of a departmental inquiry and prosecution are distinct, said the commission. 2 sealed bottles of alcohol per person is permitted to be carried inside Delhi Metro according to the DMRC revised norms. However, drinking alcohol inside the metro premises is still strictly prohibited. Carrying of alcohol was banned in the Delhi Metro till recent except on the Airport Express line, the DMRC said in a statement. Metro passengers are requested to maintain proper decorum while travelling, the DMRC said. In case any passengers is found behaving in an indecent manner under the influence of alcohol, suitable action will be taken against them under the relevant provisions of law. Chief Justice of India, D.Y. Chandrachud-led 5-judge collegium has undergone a change with the incursion of Justice B.R. Gawai and Justice Surya Kant after 2 senior judges demitted office during the summer break. Justice K.M. Joseph and Justice Ajay Rastogi, who were part of the collegium, retired on June 16th and 17th respectively. Besides the CJI, the revamped collegium now includes Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice B.R. Gawai and Justice Surya Kant. Interestingly, 3 members of the revamped collegium, Justice Khanna, Justice Gawai and Justice Surya Kant, will over time become the CJI. The reconstituted collegium faces the task of filling vacancies in the Supreme Court, which will be reduced to 31 against the Sanction 34 with the retirement of Justice V. Ramasubramanian. The Kerala High Court has issued a directive to the State Police Chief urging the proper training of police officers in the provision of the Mental Health Care Act 2017. The court emphasized the importance of sensitivity handling cases involving individuals with mental illness. Justice K. Babu, presiding over a single bench, considered the suggestion made by the amicus curiae and directed the competent authorities to ensure that police officers across all police stations in the state are well versed in relevant provisions of the Mental Health Care Act. The court's directive aims to ensure proper, prompt and effective compliance with the Act, ultimately alleviating the grievance faced by the mentally ill individuals. The country's consumer protection regulator CCPA has imposed ₹1 lakh penalty on Rao's IAS study circle and slapped another ₹50,000 on Seekers Education, a coaching center for publishing misleading advertisements. Both entities have fined for making claims of high strike rates by their students in competitive examinations. In an official statement, the Consumer Affairs Ministry said that the Central Consumer Protection Authority, headed by its Chief Commissioner Nidhi Khare, passed an order against the Rao's IAS Study Circle for alleging in its advertisement that hundreds of Rao's IAS Study Circle students has aced the UPSC exam this year as well. It said that on examination, the Central Consumer Protection Authority found out that 143 aspirants, out of 143 aspirants, 101 belong to the interview guidance program, concluding that the coaching center's claim can undeniably mislead consumers with regard to its actual role in successfully clearing the exam by an aspirant. The CCPA has directed it to pay the fine. In the end, we have international news. A US appeals court has upheld a New York County's law barring anti-abortion activists from approaching people outside abortion clinics, teeing up potential review by the US Supreme Court. The Manhattan-based Second US Circuit Court of Appeals said the law adopted last year by Westchester County, New York, was valid under a 2000 Supreme Court ruling that rejected a challenge to a similar law in Colorado. Further sanctions have been unveiled against Russia as the UK announced a ban on Kremlin-linked individuals and businesses from assessing British legal expertise. The Ministry of Justice said a new law would be introduced in the UK preventing UK lawyers from advising Russian companies on certain business deals in a move designed to thwart Moscow's war machine in Ukraine from benefiting economically from world-leading legal knowledge. Officials said that the sanction could impact Russia's ability to obtain legal advice on everything from trade deals between global corporations to international money lending. The US Supreme Court has struck down race-conscious student admission program currently used at Harvard University and the University of North Carolina in a sharp setback affirmative action policy often used to increase the number of Black, Hispanic and other underrepresented minority groups on campuses. The justices ruled in favor of a group called Students for Fair Admissions, founded by anti-affirmative action activist Edward Blum, in its appeal of the lower court ruling upholding programs used at two prestigious schools to foster a diverse student population. The affirmative action case has represented the latest major ruling powered by the Supreme Court's conservative majority. The court in June 2022 overturned the 1973 Roe v. Wade decision that had legalized abortions nationwide and widened gun rights in a pair of landmark rulings. Many institutions of higher education, corporation and military leaders have long backed affirmative action on campuses not simply to remedy racial inequality and exclusion in American life, but to ensure that a talent pool that can bring a range of perspective to the workplace and US armed force ranks. According to the Harvard, around 40% of the US colleges and universities consider race in some fashion. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box. And for the weekly updates, like and subscribe to our channel.